Hi, am I audible?
Yeah.
Okay, so we will start now. We are live now. So welcome back, participants. We are live. So you can use the same link you used previously to join that webinar, but it will get expired in 1 hour time. So before 1 hour, you mean like before 1 o'clock, you have to join the webinar. And we are moving on to the next session. So we will now begin with a session on due diligence at a distance with Simon Reis, co-head at Nishid Desai Associates, talking about how investors can conduct due diligence while maintaining a distance. Parag Murali, senior fellow investments at Kerala Startup Mission, will be moderating the Q&A post the session. I now invite Simon to have the session. Please.
Thank you. Thank you all. Am I audible?
Yes, yes.
Okay. So this session is going to be a session on diligence, keeping in mind, the distancing norms that we have. But I think the session, stresses on how important diligence really is, and the fact that if even if you really want to do in an investment during the distancing times, it is not safe to assume that the diligence exercise can really be forgotten or can be postponed. So, with that, I think let me sort of start on my first slide, which discusses the definition of what a due diligence really is, right? It is, after all, a measure of prudence, an activity, or an astutity, as is properly to be expected from and ordinarily exercised by a reasonable, prudent man. And it's not measured by any absolute standard, but depends on the relevant facts of the case. Now, diligence, especially from an investment community perspective, is really required for two reasons. One is for you to properly assess what the valuation of a company should be. And secondly, from an investment committee perspective and your limited partners perspective, to safeguard against any liabilities of the general partner. Without conducting diligence, if there is a liability that arises, there can be grave implications on that. Let us maybe talk about the most talked about case, which was the Ranbaxy situation, where this company was bought from the Singh brothers by Daiichi, a Japanese entity. Daiichi must have conducted diligence, but clearly not sufficiently enough, because the main concern or the main issue with respect to the drugs that were being produced by Ranbaxy, the main real asset was whether or not they were eligible for FDA approval. And after the acquisition, Daiichi sort of found out that in fact this element had been hidden from them, that the promoters knew at the time that the sale was happening, that the likelihood of getting FDA approval for key drugs in the pipeline, which was the basis of the of the increased valuation, was a possible no. And therefore the entire indemnity claim that arose, and though this deal was done about 6 or 7 years ago, Daiichi has still not seen the color of money, despite having won an arbitration award at the highest courts, and courts in India agreeing that the arbitration award was properly obtained. So this just gives you a sense of how important diligence really is, and whether distancing or no distancing, the importance of carrying out your diligence is really something that cannot be overlooked. From an internal liability perspective, with respect to GPs, you can argue that diligence is really a matter of what's really happening, and the relevant facts at the relevant time, and therefore one could argue that even if you want to do a deal, you may have limited information at this point in time, and therefore has a threshold of diligence really from an internal liability perspective decreased. I would argue maybe not, because during these times, it is incumbent on the GP to take extra precaution to ensure that all bases have been covered, and really invest in an opportunity only after carrying out whatever needs to be done to ensure that the opportunity is in fact an opportunity and not really a threat. Now, diligences can be of various kinds. The financial diligence is commercially extremely important, but I think two sort of other diligences, two or three other diligences that are equally important. One is the legal diligence that needs to be carried out, and two other diligences that have become important in the recent times. One is a diligence on carrying out diligence on the promoter himself, some form of a forensic diligence, and another diligence really is a diligence of the corporate governance measures that the company or the target is really is has, so that from a future perspective, it is well established that the corporate governance norms in the company are such a kind that enable for information to really reach the top for proper accounting systems, and there is no um, excuse that things were carried out in a haphazard manner, as a result of which the people that you are dealing with in a diligence perspective could have never known. So in the recent past, where financial diligence, commercial diligence, um, diligence with respect to legal diligence have always been carried out. But two other sort of diligences that are really seeing the light of day now is forensic diligence, and really a corporate governance diligence. Now, adapting to distancing norms and adapting to what is really happening today, where face-to-face discussions are really difficult. Fortunately, we have something called the internet, and likely or not, the internet really gives you a lot of information that otherwise you may not really have ready or handy. And the internet, as we all know, is a base for at least preliminary information to be known, and thereafter you can inquire through conversations. And I will give you an example of what really happened in one of our large deals that we were doing. We were trying to acquire the stake of a large sort of listed company, where the promoters were doing a sell down to pay back financial creditors. um, this was a complicated structure of the promoter group, that had multiple layers, and a father-son combination, where in some sort of companies the father was the primary shareholder, and in some other circumstances the son was the primary shareholder. Now, there were a series of transfers that happened a year and a half ago, which resulted in the father transferring controlling stake of the promoter companies to the son, and the father sort of continued with a different vertical business of the company. Now, the father's vertical was really a vertical that was in the real estate, and that asset really had a lot more loans, and that asset was one that really couldn't be sold, because in the last 1 year, as we all know, real estate has really seen very limited commercial viability with respect to investors. So what happened was, we had sort of transacted with the son's vertical, and were actually 1 day from execution, when we sort of realized from a Google search, and just something that popped up into our inboxes, which suggested that there was an injunction that was levied against the father just a day before, when that injunction did not allow for the father to transfer any of its economic interests, directly or indirectly, to any other third party. Now, because the son was, an immediate relative of the father, it could be argued that the interests of the son were also the interest of the father, and therefore, because of this case, which was not disclosed to us by the promoters and not disclosed to us by the son or the father, whether it is because they didn't want to disclose, or whether they had a different interpretation of what the injunction covered. This was something that was, found by the lawyer, sort of, being vigilant on the transaction. And as a result of this injunction, the buyers, which were a large foreign fund, decided that they will not proceed with the transaction, because the consequences of violating an injunction, especially when you have knowledge of that injunction, were quite draconian. And as a result, the transaction did not go through. So therefore, doing your diligence, even simplicity or primary Google diligence from a forensic perspective, which can be done whether distancing norms are applied or not, is extremely important. Now, let's sort of discuss the purpose of diligence. It is really to understand the target better, to test the assumptions that forms the basis of the transaction better, to help determine valuation, to identify risks, liabilities, commitments, to minimize the risk of unexpected situations, to check if there were any shortcomings of the target, to check if the shortcomings are adverse in nature, and really to provide mitigating circumstances or mitigations, whether it's through certain indemnities, certain walkaway rights, certain sort of conditions precedent that must be fulfilled prior to you undertaking the deal, certain valuation adjustments, it all, having information really allows for you to arrive at a perfect solution, even if you want to go ahead and do this transaction. Now, we've sort of been asked by many of our clients, can we really do the, because diligence really, especially a legal diligence, is mainly documentary in nature. And documentary in nature means that you have to have physical documents or some form of documentation with you to verify. Now, some people may ask, saying, look, documentation is not something that is possible to get. We've understood the financials of the company before lockdown. We've understood the financial, the appetite of the company. We've understood how it really works. Can we sort of can we invest now and do the diligence later because of distancing concerns or issues? Now, I would sort of argue, depending on what the appetite of the company, of the investor really is, and whilst some aspects of a diligence can be done as a condition subsequent after the investment is done, you cannot really eliminate basic diligence being done as a condition preceding your investment. You could also have a situation where an agreement is signed today just to capture value. You say, look, we will conclude this deal only when we sign up. We have a firm agreement, but one of the conditions of this deal is really us being able to do diligence, as would be required of a reasonable investor, and we can do that diligence as a condition precedent. Once that condition precedent is satisfied, and we have the outcome of the diligence, if there are any tweaks to the structure, if there are any tweaks to the valuation, if there are any additional indemnities, conditions, subsequents, or we can sort of agree to that, and only if we agree to those conditions will we do the deal. So it can be a conditional agreement that is entered into now, with diligence being a condition precedent. That is a midway solution that could perhaps be done during these times. But I will share with you sort of another example that we had. Now, you would look at sort of companies in terms of what diligence needs to be done depending on the sector that you are in. You would argue today that a technology company, right, you would want to do two basic legal diligence checks. One is IP, and second really is employees, and third is really customer checks, all of which I suppose could be done over a phone call and don't necessarily need physical documentation. Now, in a case that we were doing earlier this year, this was our approach as well. This was a usual deal where the diligence was quite thorough. In fact, this company had subsidiaries all over the world, and the bulk of the revenues really came from the U.S. But this was a Indian company having subsidiaries in the U.S. and subsidiaries all over the world, and the Indian company shares were being transacted. All the core matters came out correctly, right? You had situations where the IP was fine. You had customer checks were done. So you would argue that the core assets were properly diligenced. But when we were doing the corporate diligence, and we sort of went back 5, 6, 7 years doing the corporate diligence, we realized that in fact what the company had done in its early years was issue shares at a discount. And that was, and as if we are familiar with the Companies Act, you would know that under the Indian Companies Act that is prevalent today, you cannot issue shares at a discount. If you issue shares at a discount, those shares can be treated as being void. Now, obviously, the company did not know it. The discount was only a ₹1 discount. But the promoter was so concerned because about 80% of its holding was really shares issued at a discount. And given that he was liable for the title of those shares, and given that he was selling 20% of the company at this point in time, and the investor chose to buy shares that were issued, the non-discount shares as opposed to the discount shares. The promoter was so concerned that he was concerned that if for any reason his shareholding was considered to be void, he would be depleted of his entire share capital in the company, and would have lost an asset. And because of this finding, he said, look, let me try and resolve this first. Let me try and see what I can do to resolve this first, and then do a transfer to you, because this is not something that I can do at this point in time. So even in certain circumstances where you have the core assets being tested, you have sometimes that is unprecedented matters can actually prevail, and promoters may not really want to do a deal because of a finding that their shareholding itself is a matter of is questionable. So, doing a diligence as a condition precedent, to my mind, is something that really, even during these times, cannot be dispensed with. And even in a company that you would otherwise only diligence core assets, matters like even uncore assets, like just the basic health of the company, should be diligenced without exception. Now you may argue, how do we do this? Now, there are limitations to what is available publicly in the Indian, through public sources. A lot of the corporate material is really available publicly. Unfortunately, for COVID reasons, the Register of Companies in India has stopped really working, and has also sort of put a lockdown on information that can would have otherwise been able you would have been able to sort of download publicly. There has been a stop on that information, but hopefully post lockdown for most parts of India, May 3rd, perhaps the lockdown would be lessened for most parts of India, and so public information would then become available. So a lot of information, whether it's IP, whether it is registered IP, information with the Register of Companies, with Register of Companies for LLPs, even some amount of litigation is information that is available publicly. So use these resources to at least do a basic diligence check, even if you can't really get information physically delivered to you. So, moving on to the next slide, in terms of diligence in different scenarios, depending on the kind of deal that you're doing, whether it's M&A, joint venture, financing, the kind of diligence that you would do really would be different. From an M&A perspective, you would want to assess, the assets, liabilities, and commitments of the target. For a joint venture, you would also want to know the assets and liabilities of the joint venture partner, and not just the target entity. from a financing perspective, you would want to ensure that the status of the company is fine, the what the security interest really is, and the viability of the cash flows of the project. From an IPO perspective, capital fundraising, again, the assets, the commitments of the targets for to assess what is really a risk to the investing public. The asset purchase, you don't really need to bother much about the target itself. You just need to concentrate on the asset and the validity of the title to the asset. And commercial agreements being entered into, you need to understand the viability of the transaction, and the really whether the contracting parties are able to perform. So we had a situation where there was a commercial agreement being entered into in the renewable space, renewable energy space, where companies were looking to develop and to augment a certain solar project. Now, the main issue here that the contract was really entered into, but the main concern today is really a lot of parts are being imported from China. Now, in these circumstances, when you're entering into a contract, or you've entered into a contract, is this really a time-bound contract? Can this contract really be given effect to? And what really happens if you cannot buy from China? Is there a price valuation to be relooked at? Is this a force majeure event? So these matters, especially in today's world, become very important when you're entering into a pure commercial agreement. So diligence not only on the project, but also the how the contracting party is going to perform its contract, and and what are the vendors of the contracting parties, are things that you need to look into, especially in today's time. Okay, we've dealt with stages of a due diligence. In a typical situation, you would have diligence being conducted, full-fledged diligence being conducted prior to the definitive agreements being signed. But like I said, as a midway for today's scenario, you can have even a diligence being done as a condition precedent to the deal closing, if you need to sign an agreement, immediately to capture the deal. In a legal diligence, the main areas that are covered are really corporate. This is to assess the health of the company. Now, like I said, whilst there are a lot of information available in the public domain with the register of companies, there are various circumstances where companies have not filed forms with the ROC, and also you would want to look into things that are more than what has just been filed with the registrar of companies, like minutes of meetings, minutes of shareholder meetings, certain registers of the company to tally and see that the company is in fact performing or has all of its data correctly recorded. These matters again are matters that you would want to diligence over and above what is available publicly. Now, employee matters are becoming matters of great importance. What are the contractual obligations with respect to the employer? Are they unionized, not unionized? From a are the various policies, whether harassment policies, whether it is from a any sort of beneficial policies that the company is required to maintain for its employees, have they really complied with those policies? That becomes very important. None of the employee matters are matters that are really available publicly, so this becomes really a matter that needs to be done basis documents that you requisition from the company. Material contracts, you look into very deeply to see how whether the company is really protected by way of legally enforceable contracts, or are things done on a purchase order to purchase order basis. Material contracts have various hidden terms, whether it's an indemnity, whether it's a liability, whether it's liquidated damages, whether it is product liability. Change of control sometimes requires approvals from the customers. Use of data, how who is really performing these contracts? Can you subcontract? IP infringement. So material contracts, in addition to just pure commercial terms, really sets out the obligations of parties, and also sets out the liabilities of parties, which an investor might inherit on a going forward basis. Now, we've seen, there was an interesting deal that we were doing, where one of the terms of the contracts really had a hidden non-compete clause, which said that, as a result of this agreement that you have signed, you are not unable to work with the companies of the same or similar nature as ours. Now, that would have a great valuation leak for the target company, because the customer in question was really a customer in the FMCG group, and this was sort of an ITS services company. Now, if you couldn't really work with companies in the FMCG group, the universe of customers really decreased largely, and this became a deal breaker really in a deal. The non-compete became a deal breaker. To get the FMCG customer to actually release the target company from this non-compete became difficult. And given the sensitivity and and how large this customer really was, the target company didn't really want to ruffle any feathers. So diligence of material contracts becomes very important. Hidden terms become very important in terms of what the liabilities are on a going forward basis. Typically, you wouldn't really look at all contracts, you would look at just material contracts, and therefore the term material contracts. Compliances, regulatory filings are again extremely important, but the importance of this in terms of the licenses is something that everybody knows. Loans and borrowings, especially in today's time, become very important. As we all know, cross defaults, whether there's a guarantee, and how and what is the loan really give a right? What does the lender really have in terms of the right to convert into equity becomes again very important. We had a deal once where there was again a hidden term in the loan documents. This was not a bank. This was an NBFC that had granted a loan to a company, and one of the terms was that the NBFC could convert the loan at par value. Um, Given the health of the company, and given what the NBFC, given the right of the NBFC to convert the loan into equity at par value, resulted in a great concern for the investor, because he would get completely diluted out unless a waiver of this condition precedent, unless a waiver of this condition was received. The investor was not willing to fund the target company. Fortunately, the NBFC agreed to sort of waive this clause, and therefore the deal went through. But loans and borrowings, fine terms in the agreement, and how what concessions do you require from the lenders at the time of investing, again important. Now, loans and borrowings again are not matters that you can find under the with the register of companies, but what you can find is really the list of charges that have been created vis-a-vis the target company, including it gives you a fair sense of who has a charge over what asset of the company, by doing a simple ROC search. Property, tangible and intangible, we've discussed in intellectual property. This only comes into question for real asset heavy companies. Again, our systems are such that we don't necessarily have a central database, which the government is now working on with respect to property. But this is also a diligence that is important for a tax for an asset heavy company. Tax, insurance, and litigation, I think I'll bucket into one. Litigation, who has what claims against the company are extremely important. Um, there are softwares today that give you a sense of what litigations and what courts have where suits have been filed. This is not an exhaustive search. As we know, our court system is not exhaustively centralized or on a central line from a database perspective. But there are softwares today that give you a sense of what litigations have been filed against the company, against the promoters. And we've done sort of we've used the software quite extensively to find out things that the company didn't really sort of tell us. Now, even litigations that have been closed can have consequential or consequential sort of repercussions, which are important to understand. Insurance and tax typically is done by financial diligence. Insurance, is policies in terms of what policies the company has, and how well has it protected itself from risk, is another matter. Insurance policies are not policies that are available publicly, so this is something that you would need the company to do. Now, typical key issues are matters. I can share this presentation to the team. We've discussed some of these. These are typical issues that you would find in a diligence. But I will sort of concentrate on just one aspect. Now, typically you would think that a diligence to be conducted, based on the fact that it is really documentary in nature, would require for people to actually visit offices of companies and look at papers, which requires a lot of contact. That is not really true. You have a lot of diligences that are done online. However, it does so you have virtual data rooms, which can actually house data. It does require, however, the company to load information into that virtual data room. So that is one step that the company needs to do. But if that happens, then you don't need to go anywhere. You can actually conduct a diligence from the sanctity of your home itself. And we've it's been very rare where information has really been there's been a physical diligence in the recent past. Virtual data rooms are far more efficient. There are certain aspects like registers, etc., which companies insist on, especially board minutes, shareholder minutes, which the companies insist on, physical presence. But in these times, even those can be really uploaded on virtual data rooms. Confidentiality is key. So there are virtual data rooms that ensure confidentiality by ensuring that the viewer is not allowed to print, the viewer is not allowed to copy, and you only have the ability to view. So confidentiality is something that virtual data rooms actually cover, and cover pretty well. So it is not necessarily required for people to actually visit the site to do legal diligences. Of course, visiting the site, visiting the plants are also important, a part of a commercial diligence. That may not be, you may not really be able to compromise on that. We had an interesting case actually where a large private equity fund was doing a diligence, or was doing really a investment into a real estate company. And all looked well, the company did it looked well. You had really the investor looked at various plans, sanction plans, but the only thing the investor did not do was do a physical inspection of the site. Had if he had done that, and even if he hadn't done that and just done a search on Google Maps really, and done a satellite imaging of the project, which again are techniques that you can use especially in distancing times, he would have found out that the project, or the land that was supposedly the land on which the project was going to be built, was actually a lake. It was not land, it was actually a lake. Unfortunately, this step of the diligence was not done. And then when the project took time, and 2 years, when the investor actually flew down to see what was taking so long, he realized that the project was not, there was no land, this was just a lake. So sometimes physical diligences cannot be dispensed with. However, you can do things like satellite imaging, to see especially where the project really is, and what the factory looks like. We had another situation where this was a company in Gurgaon that had, had sort of projected great revenues, great EBITDA, great projections. But when diligence was sought to be done on where this company existed, there wasn't a factory or wasn't any sort of office to be found. So sometimes dispensing with physical, doing a diligence physically cannot be dispensed with, but as a compromise, you can always do a Google or a satellite sort of imaging. Another thing that we sort of did recently in a renewables deal. Now, as you may know, renewable energy today, especially building a solar plant, it has a lot of concessions from the government. You enter into a power project agreement, you enter into a concession agreement, and all of those have real milestones. And unless you complete the milestones within the milestone check, it is not something you can't really get. The final OC, the final operational certificate, allowing you to actually operate the project. And if you've not completed the project within a stipulated amount of time, then there are penalty clauses, and any operational certificate that has actually been issued in derogation of those milestones is a certificate that can really be can be removed, or can be cancelled or declared void. Now, when you have a project being done, you don't necessarily know. You have to sometimes rely on you have to rely on the promises made by the project developer, saying that, yes, these milestones were in fact completed within the time that was required. In a project that we were looking at, it was nearly the final stages, and there was a random sample check done with respect to the various projects, but not a full diligence done on every project that was being acquired. Just as a matter of precaution, this was sought to be done as the last step. When they went to the various sites, they realized that various solar panels were missing. So therefore, the operational certificate that was received really was also done on a random sample check, and there were concerns or issues as to how that certificate was actually obtained. And so there was a lot of back and forth on ensuring that these matters were done in the most kosher way, and only because they had done a physical diligence did they realize that there were corrective measures that needed to be done, and discussions to be had as to whether there was any element of fraud, or whether this was something that was overlooked by the regulatory authority when granting its approval. In distancing times, certain assets you cannot dispense off with physical diligence, and therefore it may be worthwhile to suspend or just proceed with caution until you can actually do a physical site inspection to a certain no liabilities for you on a going forward basis. Now, from when you've done, especially venture capital companies that really focus on a startup or young companies, like I think the audience really is. There are core aspects that need to be looked at, and I would think that matters that venture capitalists have really a strong role to play in shaping up a young company. Now, very often, a startup company or a young company has limited advice when starting up, and when and starting afresh, and therefore many things can really go haywire. We had sort of looked at a company that had started off, ground up, and realized that, in fact, the trademark that was filed by the promoter and not by the company. So the IP was actually held by the promoter and not by the company. by the company. We had sort of realized that even the copyrights that were sought to be done were in the name of the promoter, and not the company. So a big sort of faux pas that needs to be rectified before a VC entity can actually take care of. Then there have been sort of circumstances where companies have just not complied with the Companies Act, not complied with various, not gotten various licenses, because just not because they didn't want to, but because they didn't really know. Therefore, I think venture capitalists and VC funds really play a very important role in understanding what the company has done. We had recently, done looked at a company that had taken a call on a sector. Now, this entity was really engaged in the business was extended warranties. Now what they did was they sort of they had an extended warranty program. Now, as we know, appliances like TVs, etc., etc., all have a product warranty coming in from the manufacturer itself. This entity, what they did was they sort of agreed to extend that warranty for the consumer, and say that we will, over and above the manufacturer warranty, if the product, something goes wrong with the product for another 4 or 5 years, we will repair it for free. We will or we will replace the product. Now, this was a VC company. This looked like a great opportunity, but what the entity didn't do is take perhaps proper legal advice, because really such a company is really treading on the ambit of being an insurance company. Now, the minute you are an insurance company, you cannot really do any business with respect to insurance, and therefore this was a big faux pas that the company really had. And had they taken advice properly, you would really realize that the business activities was one that was technically regulated, or could be regulated, and wasn't really as simple as they seemed. So therefore the VC investor is really saddled with the task of ensuring not only that the assets are properly registered, but really that the business that the company is doing is one that is kosher, doesn't require any additional regulations, doesn't require any additional registrations, and there's no real liability on the promoter or the company from carrying on what they are really doing. So legal diligence in a venture capital company is important. Now, this primary diligence and a robust legal diligence at this stage doesn't really require physical interaction. Just a phone call of understanding the business and what approvals have been taken is sufficient for somebody in the legal fraternity to understand and to guide whether any additional approvals were required, and ask pertinent questions to arrive at a conclusion as to whether the business is really kosher or not. So, this is something that should be done no matter what. I think I won't really cover things that are governed in a private equity transaction, because this group is more venture capital. I think I will sort of move to sort of slide 19, which says that diligence items really translate into four main aspects. One is price. Second is structure. Now, in this example of the warranty, extended warranty, we had to change the entire business model to ensure really that the business model worked from a regulatory perspective, and that from a cash flow perspective, really there wasn't an exorbitant stress on the balance sheet, making the business unviable, or not as commercially viable as would have been had there been no regulatory interface. Um, so therefore it can result in a structure change. documentation in terms of indemnities, and liquidated damages and specific indemnities, and liabilities for the promoter. And last is really, is it a deal or no deal, is what the diligence items really translate. We've discussed really the importance and the benefit of doing a legal diligence. And now, Parag, I think I will sort of open this for questions, because I think we do have about 10 minutes left. Parag? Parag? Parag?
Hi, I think Parag is offline. I'll reconnect with him.
Sure. Okay, there are some questions which I can sort of
Yeah,
ask. One is, I think someone says, yeah, I can definitely share this PPT to on Gmail, no problem. It is difficult to
sure.
check integrity. Someone says, beyond a point, how do you cover this? Look, there are sort of experts that deal with this. That forensic experts that deal with this. You are right. There is it's difficulty to check integrity, but really it is a gut and feel test more often than not. Conversations with past employers, really, what is the appetite? It's a gut and feel test from an integrity perspective. But if you want a full forensic diligence, there are experts that actually do this, and we found them to be really quite useful. It really also depends on how forthcoming the individual is. Sometimes the forensic diligence is done quietly, discreetly, and most times it's done discreetly. Sometimes it's also done once forensic information is known. Sorry, there is some background noise. If others can put the phone on mute,
Yeah,
please.
yeah. It's turned off.
Yeah. So so that's the question on integrity. The next question, I think, from Gopal is, I think the message to the entrepreneur should be that they have to be transparent on their dealings. I think you are right, because look, from an entrepreneur perspective and a promoter perspective, the relationship between investor and entrepreneur has to be looked at as a long-term partnership. It is not an immediate cash injection. And therefore, the gut and feel test of what the promoter really wants to do on a going forward basis is important. uh, from a promoter perspective, if you've disclosed everything, you have less liability, and you can sleep easy. Hiding things never really works. And I'll give you the example of the sort of Daiichi Ranbaxy situation. I mean, these brothers have been fighting this case for so long now, and every day there's been, either in jail, not in jail, and you can just see what's really happening. So eventually the truth does come out. Eventually you do get saddled with a burden, especially in today's environment where everything and anything is really recorded and is public. So there isn't really much that you can do other than be transparent and upfront, because unless you do that, you always have this liability really on your back. So yes, and really, a diligence is really an out for a promoter. Once you've disclosed matters, the investor can take its own call, and it becomes an out for you. Um, okay, I think.
I think that's all the questions we have right now.
Yeah.
Simone, am I audible to you right now?
Yes, you are.
Okay, so my apologies. I seem to have had a mic malfunction, but then thank you for being a sport and taking on the questions yourself. And thank you for the very insightful session that was very detailed. And for the benefit of the audience, I would like to mention that in her past decade or so of M&A experience with Nishit Desai Associates. Simone has served on quite a few deals, and she served as a thought leader for on quite a few different arenas in the M&A space. And her views can be found have been covered extensively on various media outlets, and you can find more of the same online. So thank you, Simone, once again for taking the time out to do this session. And this was very insightful. Thank you once again for coming on board.
All right. Thanks all.
Thank you.
Thanks, Simon. Thank you so much.
Thank you. How do I log off?
You can just I'll just log you out. I'll push a button
Thank
here.
you. Thank you.
Okay. Okay. Thank you all. Thank you, the participants. Hope I'm audible to you. So our next session will be starting on 2:30. Actually, we have finished this well in advance. So we will be starting by 2:30 afternoon. So you can use the same link to join the call, and try to join 20 minutes before. I mean, like around 2:50, before 2:30, 2:50. You have to join. You can join using the same link. And the next session is on equity free funding schemes. Equity free funding schemes. So we will be going off live soon. You can use as and you can use the same link. Afternoon sessions will be on the equity free funding schemes and post COVID investor outlook. So at 2:30 we will begin with equity free funding schemes. So the session is hosted by the session will be hosted by Mr. Robin Alex Panikar. He'll be the moderator for the session. He's a venture partner of Unicorn India Ventures. And the panelists are Mr. Umesh IAS, Executive Director, KSIDC, Kritika Narula from Invest India, and Mr. Ranjit Kumar, General Manager of Kerala Financial Corporation. The topic is equity free funding for startups. And the second panel afternoon will be adapting to a post-COVID world. It will be moderated by Mr. Rajesh Nair, Associate Partner Markets, Ernst & Young. And the panelists are Mr. Anil Joshi, Founder and Managing Partner of Unicorn India Ventures, Mr. Vishesh Rajaram, Managing Partner, Special Invest Fund, Mr. Manoj Kumar Agarwal, Managing Partner, C Fund, Ms. Padmaja Ruparal, Founding Partner, Indian Angel Network. Please log in at 2:30 afternoon. Thank you. Audience can share the questions on the chat tab itself. You have to click the chat mode button on the bottom right corner, and it will turn into Q&A mode. And you can type in your question, and it will be marked as a queue on the chat tab. Those questions will be answered.